Okay. She doesn't end it with that. Oh. Hello, good evening, and on behalf of Northumberland Learning Connection, let me welcome you to tonight's Zoom event with the Honorable Irwin Cotler. My name is Karen Wells. I'd like to begin by respectfully acknowledging that Northumberland County, where NLC is based, is located on the traditional territory of the Anishinaabe, the Huron-Wendat, the Iroquois, and the Ojibwe Chippewa peoples. This territory has been inhabited and cared for from the beginning by Indigenous peoples, and it is covered by the Williams Treaties. Thank you. We have called this evening the politics of human rights, and there's a great deal to talk about. Mr. Cotler will be concentrating in his remarks on several international issues and cases, but let me assure you that we will make time this evening to talk about some of the human rights issues, the charter rights issues that arise with this week's imposition of the Emergency Measures Act. And I would imagine that several of you will have questions on that subject. This is how the evening will work. Mr. Cotler will speak. I have a couple of questions to ask, and then we'll put your questions. So many of you know the drill. Send in the questions. Succinct is good, and don't forget the question mark. It's a question, not a speech. And send it in the chat function, and then we will get to as many questions as we can. Now, I'm going to hand things over to NLC board member Paul Macklin to introduce Mr. Cotler. Paul was, during his time as Member of Parliament for Northumberland Quinte West, Parliamentary Secretary to Irwin Cotler when Mr. Cotler was Minister of Justice and Attorney General. So Paul, over to you.
Good evening, ladies and gentlemen. It gives me great pleasure to introduce Irwin Cotler, a man whose accomplishments are larger than life's expectations, and who I was pleased to work with in Ottawa while he was the Minister of Justice. From an early age, his parents instilled in him the importance of justice and ethics. By way of example, at age 6, his father took him to a baseball game in Montreal, in which Jackie Robinson, who would go on to be the first Black person to play Major League Baseball, was playing. This was a teachable moment about civil liberties, anti-racism, and dangers of segregation. By age 11, he had learned from his father about the Holocaust and had come with his dad to Parliament Hill. When I was with Irwin some years later in Israel at Yad Vashem, the Holocaust Memorial, the staff revealed to him that their research had indicated that over 87 of his relatives had perished in the Holocaust. After receiving a law degree at McGill University, he began his academic career, which took him as a professor first to Osgoode Hall in Toronto, and ultimately to his alma mater, McGill Law School in Montreal. 7 years ago, he founded the Raoul Wallenberg Centre for Human Rights, which is dedicated to promoting human rights, advocating for political prisoners, and combating injustice around the world. Irwin founded this organization in memory of Mr. Wallenberg, a Swedish diplomat who saved 100,000 Jews during the Second World War. On meeting Irwin in Ottawa, I would clearly state that on the day he was sworn in as Minister of Justice, it was truly historic, for to my knowledge, he was the only justice minister who had ever been arrested at least twice in 2 different countries, and ultimately banned from and poisoned by Russia. Defending human rights is not for the weak-hearted. As Irwin clarifies, the major lesson on seeking the release of political prisoners is not the injustice of the case, but it is when you can make the case that it's in their self-interest to release the prisoner because it's costing them. If there's an opportunity tonight, please ask him about how he came to marry his wife, Ariella, on March 26, 1979. It's quite revealing about Irwin's influence and respect in the Middle East. He has been honored by at least 15 Doctor of Laws degrees and can be addressed as Professor, the Honorable, or as Nathan Sharansky referred to him, the most idealistic and at the same time professional defender of human rights in the world. We are so pleased and honored to have you with us this evening, Irwin. Welcome to Northumberland Learning Connection.
I want to say, Paul, that is one of the most moving introductions I've ever received. And I have to say that our time together in the Ministry of Justice brings back the best of memories. You were an exemplary parliamentary secretary. I regarded our work together as a joint partnership in the pursuit of justice. And you reminded me of my first lessons about justice that came from my parents of blessed memory. It was my father who taught me at a very young age, before I could really understand the profundity of the teaching, when he said to me that the pursuit of justice was equal to all other commandments combined. But it was my mother who, when she heard my father saying this, would say to me that if you want to pursue justice, you have to understand, you have to feel the injustice about you. You have to go in and about your community and beyond and feel the injustice and combat the injustice. Otherwise, the pursuit of justice will remain a theoretical abstraction. I suspect that these teachings of my parents underpinned my work all these years. And I want to, at this point, commend also the NLS for bringing us together at a very timely moment. Indeed, we meet at what I would call a historical inflection moment, where we are witnessing and experiencing a number of pandemics. The COVID-19 pandemic, where we have witnessed and experienced human suffering, death, and devastation, disproportionately impacting on the most vulnerable amongst us. And I want to pay tribute to the frontline responders who have been so engaged in these efforts of preserving health and human life. The second has been the pandemic of systemic racism, targeting Indigenous people in Canada, Blacks and people of color, Muslims and Jews. The third has been a pandemic of disinformation, of hate speech that is not only amplified in the social media, but where the social media are themselves weaponized for that purpose. And the subject matter of this evening, a global political pandemic characterized by a resurgent global authoritarianism, the backsliding of democracies, assault on human rights, and political prisoners as a looking glass into this global political pandemic, which is itself underpinned by another pandemic, the pandemic of impunity. And so I will share with you 4 case studies of this global political pandemic through the looking glass of political prisoners, and where we will see the impunity, regrettably, that underpins this, and the human rights advocacy that is necessary to address and redress these human rights violations so that we can help secure justice for the victims and accountability for the human rights violators. The first case study is that of Xi Jinping's China. And I use that term to distinguish it from the people and publics in China who are otherwise themselves the targets of oppression. And where we have Xi Jinping targeting what he calls the 5 poisons, these being and finding expression in the mass atrocities against the Uyghurs, in the frontal assault not only on the democracy movement in Hong Kong, but on democracy itself, on the persecution and prosecution of the Falun Gong, a spiritual meditation movement, on repression in Tibet and the menacing of Taiwan. But it doesn't end there. What is not so well known, but deserves to be known and acted upon, is that China actually imprisons more journalists than any other country in the world, as well as the lawyers who would defend them. That it was this suppression of information, this arrest of doctors and dissidents that helped lead to the COVID-19 spread at the time in end of 2019. And where we have seen a number of international inquiries in that regard, and in particular, where the Canadian Parliament became the first parliament, since followed by others, UK, France, etc., to make a determination that the mass atrocities targeting the Uyghurs are acts constitutive of genocide, including the incarceration of more than 1 million Uyghurs in concentration camps where they have been enslaved, abused, violated, raped, and even murdered, where we've seen massive sterilization of Uyghur women as part of coercive population controls, the forcible separation of Uyghur children. At the time that we reported on this, it was 500,000, and that has increased substantially since then. The targeting of the Uyghurs' religion, culture, identity, and belief, and destruction of their mosques. And finally, state-sanctioned incitement to hate and genocide, where Uyghurs have been referred to as cancerous tumors and the like. And so it was that when I testified before the Canadian Foreign Affairs Subcommittee on Human Rights as a prelude to then them adopting a parliamentary determination that the Uyghurs were being targets of genocide, acts of genocide, I said that one of the things that struck me as we were analyzing this were the words of former Nobel Peace Laureate Professor Elie Wiesel, who warned us of the dangers of silence in the face of evil, of the dangers of indifference and inaction in the face of mass atrocity and genocide, who spoke of how neutrality or indifference always means coming down on the side of the victimizer and not on the side of the victim. And one of the human rights lessons that I've learned over the years is that what made the Holocaust and the genocides that followed, such as the genocide of the Tutsis in Rwanda, where 10,000 Tutsis were murdered every day for 3 months. What made these genocides, and we can go on with regard to Darfur and more recently to the Rohingya and the Uyghurs, what makes these genocides so horrific are not only the horrors of the genocides themselves, that would be bad enough. What makes them so horrific is that they were preventable. Nobody could say we did not know. We knew, but we did not act. Just as in the case now with regard to the Rohingya and the Uyghurs, we know and we are not acting. And with regard to China, let me just mention 2 political prisoners as a looking glass in that regard. The first is Dr. Wang Bizang, a doctor from China who came to McGill University in 1975, received a PhD in medicine from McGill in 1982. Both of these political prisoners I'm mentioning have clear Canadian connections. Dr. Wang Bizang's siblings, children, parents, etc., all became Canadian citizens. But he decided after receiving his PhD that while it would be good to be a doctor, it was more important to advance democracy in China. And so he established the Overseas China Democracy Movement, then based in the US. Fast forward to 2002 on a visit to Vietnam. He was abducted from Vietnam, brought back to China in a sham trial, closed, unrepresented by counsel. He was sentenced to life imprisonment in solitary confinement on the convictions of both treason and terrorism, where he has suffered a series of debilitating strokes in prison. And when his daughter, Tiana Wang, named after Tiananmen Square, sought to visit him after finally getting permission after years of being denied to do so, and in January 2019, she arrives at the Beijing airport with her little infant, now the grandson for Dr. Wang Bizang, only to be turned back and not allowed to visit him. And I won't go into more of those particulars, but a cruel action in that regard. The second political prisoner, and with a Canadian connection, is a Canadian Uyghur by the name of Hussein Chalu. I recall when, as a member of parliament, we had hearings into his situation in 2006, but what happened with Hussein Chalu is that he was abducted from Kazakhstan, brought back to China, not permitted, and has since not been permitted to either have any visitations from family, for any visitations from Canadian diplomats. He's effectively been a forcibly disappeared person in solitary confinement for now 16 years. So both of these political prisoners with their Canadian connection are a specific looking glass into the larger human rights violations in China, and regrettably, the culture of impunity that underpins it. This brings me to the second case study, and that is of Khamenei's Iran. And here I want to mention two political prisoners as a looking glass into the larger, widespread, and systematic violations of human rights in Iran. The first is Nasrat Suttada, an iconic Iranian woman, human rights lawyer. I first got involved in her case in 2011 when I was then a member of parliament. She was then repeatedly arrested until 3 years ago. This woman who had gone down the line for the women's movement in Iran, for juveniles destined for execution, for journalists whose speech had been silenced, for religious minorities like the Baha'i who were subject to persecution, to environmentalists who had been arrested, for other lawyers who had themselves been imprisoned for taking up the cases of political prisoners, for other political prisoners themselves, until she 3 years ago, and we now just about the eve of the third anniversary of her conviction and sentence to 38 years in prison and 148 lashes, a virtual death sentence for a woman in her late 50s. And as we meet, she languishes in Korchak prison, regarded as the end of the world in Iran, with a high incidence there of COVID-19, where she has gone on strike on behalf of other political prisoners and their health and welfare while in prison, denied even the medical treatment that is deserving for her in these conditions. And yet, astonishingly so, Iran was elected within 2 days of her conviction to the United Nations Commission on Women's Rights. So not only a culture of impunity, but impunity being rewarded. And I am a great believer and promoter in the Universal Declaration of Human Rights, which was so compellingly framed in the introduction this evening in the slides. But regrettably, Nasrat Suttada's case is a case of the systematic and widespread referencing of the violations of those human rights in Khamenei's Iran, which brings me to the second case study there, and I'll be brief, but here a specific Canadian connection as well. It's with regard to the Iranian Canadian dual citizen, Risa Islami, who happens to be a graduate, a PhD graduate in law from McGill University, a student while I was teaching there. Risa Islami went back to Iran, became a professor of environmental law, went to a workshop on environmental law in the Czech Republic a little over a year ago, and then on his return in February 2021 was sentenced to 7 years in prison for doing nothing other than being part of an environmental law workshop. And I might add that this occurred at the same time as Canada led the adoption of a declaration on arbitrary detention in state-to-state relations for the protection against the use and abuse of hostage diplomacy in matters of dual nationals, let alone in this instance, the unjust imprisonment. And yet here, another case with a Canadian connection and violation of fundamental principles in the Universal Declaration of Human Rights, which leads me now to a third case study, and that is that of the imprisoned Saudi Arabian blogger Raif Badawi. And here too, a clear Canadian connection. We are now approaching the 10th anniversary of Raif Badawi's imprisonment, where he was convicted for saying 10 years ago what Mohammed bin Salman, the crown prince and leader of Saudi Arabia, has himself been saying for the last 5 years, namely calling for a more open Saudi Arabia, for a more moderate Islam. As well, his sister, Samar Badawi, was imprisoned for calling for the women's right to drive, a reform that Mohammed bin Salman himself instituted, but then imprisoned all the women who had called for that right to drive. And so we had a situation, I might add as well, I should not leave this out, that his lawyer, Walid Abu Khair, was sentenced to 15 years in prison for doing nothing else than representing Raif Badawi as authorized under Saudi law, as authorized under Islamic law. I might add that I have petitioned for the release of Raif Badawi in a petition based not on Canadian law or American law or European, but on Saudi law and on Islamic law. The Crown Prince did respond to that petition, and we have been exchanging in that regard. On February 28th, Raif Badawi is scheduled to be released. However, if he is released on the due date, he is not thereby freed. I say that because his initial sentence was not only a 10-year imprisonment, but a 10-year travel ban, a 10-year speech ban, and a punitive fine of some $330,000 in Canadian terms. And that 10-year travel ban means that his wife and children, he has 3 children, who came to Canada initially as refugees and have become Canadian citizens and have been here since 2014, not long after he was imprisoned. His wife and children have been deprived of their father, husband. So there's been human suffering involved here, and that suffering will continue if, when the due date for his release arises, and he is not yet, and he is released but not permitted to return, then he ends up being in a kind of prison without walls. I just want to conclude this case study of Raif Badawi by mentioning that some 3.5 years ago, the then Foreign Minister of Canada, Chrystia Freeland, tweeted a call for the release of Raif Badawi and his sister Samar Badawi. The Saudi authorities then erupted in fury. They ejected the Canadian ambassador from Saudi Arabia. They recalled the Saudi ambassador from Canada. They suspended all trade and investment with Canada, and they recalled 15,000 Saudi students studying in Canada. In effect, a self-inflicted wound. But why I'm sharing this with you is because 2 months after that situation, that horrendous infliction at that time of the punishments that were then incentivized with regard to Raed Badawi and his sister. What happened then, 2 months later, is, if we recall, was the brutal murder of the Saudi journalist Jamal Khashoggi. But it was the silence of the democracies when all that occurred, when Chrystia Freeland tweeted a call for Raif Badawi's release and Samar Badawi's release. The silence of the democracies, where not one democracy came to their defense and to Canada's defense. And as I wrote at the time, that then took us down the road to the brutal assassination of Jamal Khashoggi. And so the dangers of indifference and inaction in the face of these human rights violations and the impunity which underpins it. Which brings me now to the final case study, and that is of Maduro's Venezuela. Some 5 years ago, I was appointed a member of an Organization of American States, OAS, International Commission of Inquiry, to look into whether there are reasonable grounds to believe that crimes against humanity were being committed in Maduro's Venezuela. I joined 2 judges who were part of that commission of inquiry, Judge Santiago Canton from Argentina and Judge Manuel Robles Ventura from Costa Rica. And we undertook our commission of inquiry, which included hearings at the OAS headquarters in Washington and the like. And we reported in 2018 that there were reasonable grounds to believe that 7 major crimes against humanity were being committed in Venezuela, which included not only multiple murders and some 12,000 cases of arbitrary detention and deprivation of liberty, but some of the worst cases, as Judge Ventura Robles said, some of the worst cases of torture that he had ever witnessed in all his time on the bench. It included case studies of rape and sexual violence. But perhaps the worst of the crimes against humanity was state orchestrated deprivation of food and medicine. In other words, state orchestrated human suffering. Upon our report some 3 months later, the then Foreign Minister of Canada, Chrystia Freeland, led 7 countries in the first ever collective referral of a state party to the International Criminal Court, namely Venezuela, to the International Criminal Court for prospective investigation and prosecution. I regret to say that even though Venezuela is a state party to the International Criminal Court, even though we had the first ever collective referral and still the only one in history of the referral of a state party to the ICC, there's been no prosecution, yes, or proceedings with respect to those that have, where we made our determination regarding crimes against humanity in that regard. But I just want to leave you in this matter with a particular case that came before us in our hearings. And that's the case of Judge Maria Lourdes Afiuni. She had some 12 years ago acquitted a political prisoner in Venezuela. The result of that is that she herself then became a political prisoner, brutally tortured in detention. And when her initial sentence was concluded, she was sentenced to yet another 5 years in prison on an invented charge of spiritual corruption, and languishes in prison as we meet. And yet again, another Canadian connection, in as much as I have been acting on her behalf, and so has the Raoul Wallenberg Centre, and we have initiated representations and petitions before the UN Working Group on Arbitrary Detention and the like. So this concludes the 4 case studies. And these case studies really ought to serve as a wake-up call for us, because they're not only case studies of a global political pandemic. They're not only case studies of political prisoners as a looking glass into those global political pandemics, but they are a looking glass also, unfortunately, to the culture of impunity that continues to underpin these unjust imprisonments and to incentivize the continuing human rights violations. And so if I can make a suggestion to the NLC and the excellent work, NLS, and the excellent work that you do, is to suggest that you might want to take up the case and cause of one or more of these political prisoners, whether it be a Nasrat Suttada, the iconic Iranian woman human rights lawyer, or the imprisoned Canadian Chinese Uyghur forcibly disappeared, or that of Raif Badawi, forcibly separated from his family, or the case of Judge Maria Lourdes Afiuni, or some others that I can mention. But I do think that we have an opportunity to help not only to address these human rights violations, but to help secure justice for the victims and accountability for the human rights violators, all in the spirit of the Universal Declaration of Human Rights, which we will give effect to by our engagement. Thank you.
Thank you very much, Mr. Cotler. Thank you so much for that. I wanted to ask you one thing in particular. Where do you go, as it were, to argue these situations? I mean, there is a lack of an international tribunal to which everybody belongs. There is the International Criminal Court, but the United States doesn't belong to that, for instance. I mean, what avenue is there to prosecute these cases?
Well, I'll tell you, I first got involved in the defense of political prisoners in the mid-70s. And the 2 political prisoners whose cases I got involved with almost at the same time were that of Anatoly Sharansky, then a political prisoner in the former Soviet Union, and Nelson Mandela in South Africa. Both of them became really the voice, the vision of these struggles. And I sought to develop then an advocacy model, because your question is really, very pertinent one. And now, what do you do on behalf of political prisoners? And the first thing was to use the law. In other words, Andrei Sakharov, considered by some the father of the modern dissident movement, taught me the importance of the mobilization of shame against the human rights violator, and where law can be a framework for the mobilization of shame. So I basically file proceedings where possible in the courts of the human rights violators. As Paul mentioned, in Russia, that ended up with me becoming arrested myself in the Soviet Union in 1979, and years later, after defending other political prisoners, being poisoned in the Soviet Union in 2006. But the first thing is, and it's something I held steadfast for, make direct representations to the human rights violator country, which we've done also now with Badawi, with Nasrat Suttada, those who we've been. The second is invoke the resources of your own host country. So we have tried always to get the Canadian Parliament and the Canadian government to take up these cases and causes, and to get an all-party group to champion the causes of these political prisoners. The third is to internationalize the advocacy. So not only invoke our own host country, but for example, we have involved the UN, US Congress, or the European Parliament, etc. The fourth is to make representations to international bodies that have been set up, particularly the UN Special Procedures, particularly the UN Working Group on Arbitrary Detention, or the UN Special Rapporteur on Torture. And I have to say that, from time to time, we have secured relief here. Sometimes it's just getting in the case of Nasrat Suttada, to at least get her medical treatment when this was continuously denied, etc. The fifth thing has been, to involve law schools and involve law students, and this becomes a learning experience for them, but also it engages a younger generation in this struggle. Then there's the importance of the media, because unless one can mobilize the court of public opinion, then the prisoners will lapse in obscurity. So these are just some examples of an advocacy model. But the most important thing, and I've learned this from the prisoners themselves, is for them to know that they have not been forgotten, that we stand in solidarity with them, that we will continue to speak on behalf of those who cannot be heard, that we will continue to bear witness on behalf of those who cannot themselves testify, that we will continue to act on behalf of those who are unable themselves to act or even find counsel to act on their behalf. So this solidarity, we feel, is, as the prisoners have said to us, are important in terms of them knowing that they are not alone when they are in prison.
Thank you for that. I just would like to remind people, I made a mistake before. If you want to submit questions, and please do, it's the Q&A function, not the chat function. So apologies for that. One question in pursuit of what you were saying, what is the role of diplomatic relations in here and of economic sanctions? Because we saw all of that play out in the case of the two Michaels in China.
Well, you may both of them are very important. In fact, I'm a member of what's called the high-level panel of legal experts on media freedom. It was formed 2.5 years ago when Canada and the UK organized the first ever World Press Freedom Conference. The third of its kind just took place last week in Estonia. And one of my responsibilities was to look at the question of the role of diplomatic remedy on behalf of political prisoners. And what I set forth in my report, a report now adopted by the high-level panel, was that diplomatic representation and diplomatic remedy is not a matter of discretion. It's an international legal obligation. And we have to change the paradigm so that countries don't feel that it's up to political interest to make a determination of whether or not they will intervene. It's an international legal obligation to intervene on behalf of your national that is in prison in another country, and it's an international legal obligation for the imprisoning country to release that prisoner. And this brings to the importance of sanctions that you mentioned. Another report that was released by our high-level panel was that of one by Amal Clooney, deputy chair of our panel, about the importance of Magnitsky sanctions. Now, global justice for Sergei Magnitsky sanctions championed by Bill Browder, whom I met in 2010 in England and who told me about his plans to establish a world movement on behalf of the then murdered Russian lawyer Sergei Magnitsky, who discovered the largest corporate fraud in Russian history, and then was tortured and murdered for that. And so Bill Browder made it his life's mission to mobilize the adoption of Magnitsky sanctions. And I have to say that that movement has now multilateralized and globalized. It's not just any longer the US that has adopted it, Canada, which became the second country, the UK, but now the European Union, that has adopted it recently. Australia, Japan is on the road to it. So the multilateralization of Magnitsky sanctions has given it much more leverage, but governments have to impose and exercise it. And with regard to, and I mentioned China, China for a long time was immune from these Magnitsky sanctions, not because there was any objective reason for them being immune, but because countries didn't want to impose sanctions on China. About a year and a half ago, a number of us formed the Interparliamentary Alliance on China. That now has parliamentarians from some 25 countries. That has been a dramatic change in the asymmetrical relationship, where prior to that, China would bully the democracies one by one, Japan, Australia, Canada. With the formation of this interparliamentary group, that asymmetrical relationship has been reversed, and we have now been imposing Magnitsky sanctions on China. So I think that the concerted involvement of democracies, we've done it on a parliamentary level, we need to do it on a governmental level and on a civil society level. Sanctions can begin to turn things around, and the concerted action of both diplomatic remedy and sanctions can help bring about the release of political prisoners. And we saw in the matter of the two Michaels that convergence also began to work.
Can I just ask you quickly about the Badawi case? Because in that instance, a lot of this flared up because of Christopher Freeland's remarks, etc., but seems to have fallen off the map now. I mean, the Canadian government was involved. Now it does not appear to be.
You know, it's a very important point that you mentioned, Gary. You know, right after Jamal Khashoggi's brutal murder, that served as a wake-up call. The European Parliament called for Badawi's release. The US House of Representatives, the Congress, and the Senate called for his release. We had unanimous resolutions in both the Canadian House of Commons and the Senate calling for his release. But that then began to abate, and before you knew it, Saudi Arabia became the chair of the G20 in 2020. And not only was it the chair of the G20, but the Badawi case was not even brought up on the occasion of them being the chair of the G20. So you had here, again, a retreat from the necessary advocacy and action. That's why I'm mentioning February 28th, because Badawi is due to be released. We have been, and as I'm speaking to you, there will be a motion in the House of Commons that may have been introduced today or tomorrow with regard to securing again a unanimous call for his release. The National Assembly in Quebec has also done so, and we have to now internationalize the advocacy for two things. Number one, to secure the release as scheduled on February 28th, and number two, to see to it that he can be reunited with his family in Quebec so that he doesn't remain, in effect, a prisoner without walls, deprived of being reunited with his family, deprived of the right to speak, etc. So I'm glad you brought this up, because we are at the end of this month reaching a crucial point in all this case, and I hope that the international advocacy will secure his release.
What do you think the chances are that that will work?
Well, the other thing we've asked the Canadian government to do is to confer citizenship on Raif Badawi. Both houses of parliament have unanimously called on the Canadian government to confer citizenship on Badawi, because if we do that, that also enhances our diplomatic protection and remedy. Thus far, the Canadian government has not done so. I would hope that if in fact on February 28th, he is not allowed to be reunited with his family, we will confer that citizenship on him, and then begin to exercise all the diplomatic remedies, all the sanctioning remedies, impose Magnitsky sanctions on all those who are responsible for the continued detention of Raif Badawi, and mobilize an international constituency of conscience for that purpose.
We have some questions coming in, and some relate to the situation in Ottawa, but let me start with an international one. We saw a diplomatic boycott of the Olympics. Was that sufficient? Did it make any difference?
Well, I've had an op-ed published just at the beginning of this week in the Globe and Mail, where I referred to the China's being awarded the Olympic Games as being the games of shame, namely a kind of sports washing, that while they are engaged in acts of genocide, they're able also to host the Olympic Games. I should say that as a parliamentarian back in 2001, I objected to China then getting the Olympic Games in China in 2008 and set forth a number, once they were awarded it, some performance criteria or benchmarks to hold China to account. Those were not only disregarded, but China enhanced its persecution and prosecution on the occasion of the 2008 Games. And so in 2015, I objected again to China getting the Winter Games, but then again they were awarded the Games, and now it's taking place, and therefore we called it the Games of Shame. I would hope that we've learned from this, that the response has to be not one of rewarding China for its massive violations of human rights and incentivizing the impunity, but holding them accountable in all the ways and means that can be done, and thereby redeem somewhat these games of shame by ensuring that the Olympic Charter is itself safeguarded and protected, that our athletes are safeguarded and protected, and that we no longer continue to incentivize criminality, but hold those governments accountable.
Did the diplomatic boycott mean anything?
Well, I think the diplomatic boycott, which I was one of those who supported, I think it was good that it happened, because at least it meant that countries would not come there through their leadership and otherwise, and give some sense of legitimation to the Games by the leadership showing up. So I'm glad that Canada participated in the diplomatic boycott, but that was not enough. I think we needed to do more. As I said, it began with not even allowing the Games to be awarded to Beijing to begin with, but once it had been awarded, we needed to hold them more accountable, because the fact that they could continue with their violations in the run-up to and during the Games is, in fact, in my view, an assault on the very principles of the Universal Declaration for Human Rights that you so compellingly framed for us this evening.
We have a question in here, again, pursuant to what we were talking about before. And the bottom line on this question says, are economic sanctions ultimately the only way if moral suasion doesn't take us anywhere?
Well, first, I want to make a reference with regard to Magnitsky sanctions are different than other sanctions, right, because they don't punish a particular country or the people of that country, as economic sanctions, can sometimes do, and thereby people get punished and the criminals may not. The Magnitsky sanctions, and the virtue of it is that it individualizes accountability. What it says is that it will target the individuals who are responsible for these violations of human rights by, number one, imposing a travel ban on them, and number two, by having asset seizures so that they cannot continue to benefit from their assets that are deposited abroad. In effect, it helps to protect, if we speak of it in Canada imposing Magnitsky sanctions, it protects our own security, our own economy, our own integrity, and we thereby hold the specific individuals who are involved in these violations accountable. I think that Magnitsky sanctions are important, but they're not enough. We need, as I say, a concentrated and concerted and comprehensive approach that involves diplomatic remedy and protection, that involves Magnitsky sanctions, that involves the range of international remedies that can be used, that involves, for example, we did this now with the Rohingya, going before the International Court of Justice, which is something that we have been recommending that be done with regard to Venezuela because of its use of torture. And this means by which the ICJ can be brought to bear as well. So we need to utilize all the instrumentalities at our disposal, legal, judicial, diplomatic, political, economic, and the like.
Question here regarding our country, and this relates to the treatment of Indigenous people. It's basically, is this not the pot calling the kettle black? And I can think back as long ago as Glenn Babb, when he was, I believe, South Africa's ambassador to Canada, condemning the use of, quote, reservations. When we were then, Botswana, et cetera, in South Africa was much in the same situation. And this question refers to the Commission on Murdered and Missing Indigenous Women and the use of the term genocide. How do we deal with that?
Well, I think that the commission was very important. When I was a member of Parliament, I spoke in favor of it. I think it's important for Indigenous people to know that we take missing and murdered Indigenous people, Indigenous women, that they're not only not forgotten, that we will act upon that. The impunity here with respect to Indigenous women, we have a situation whereby Indigenous women are 5 times more likely to be imprisoned than white women, and so on. So there is a clear discriminatory dimension that underpins also a missing and murdered Indigenous women and the impunity that has accompanied that. With respect to the questions of genocide, I think you have acts. I have always said that one has to be very careful with regard to the use of the word genocide, because if it's used too loosely, then it will lose its the horrific nature of that determination. I think with regard to Indigenous people, there were amongst the acts committed acts that themselves could be said to be tantamount or constitutive of genocidal acts. And in fact, the Prime Minister Trudeau had made that kind of determination. I know that Beijing, said, how can you accuse us when you've done the same thing? But in fact, it's two very different things. In one case, in the Canadian case, even if one were to say that these were acts constitutive of genocide, there is, at this point, I would hope, a sustained and concerted effort with regard to not only truth and reconciliation, and Senator Murray Sinclair's commission and truth and reconciliation and the recommendations there, but what is important is ongoing accountability and ongoing acknowledgement of the crimes that have been committed against our Indigenous people. I think with regard to Beijing, it's the other way around. No acknowledgement of any criminality on their behalf, no responsibility, continuing impunity, and the continuing incentivization of that impunity. So I think the cases are not at all comparable. And I do think that we still have a long way to go before we secure justice for Indigenous peoples. And I think the land acknowledgement with which we began this evening, the fact that this has become, at this point, de rigueur, but it also has to be not just an affirmation, it has to also be ongoing action in that regard. When I was Minister of Justice, I won't forget the then Prime Minister Paul Martin, at our first cabinet meeting, said to us that the struggle for Indigenous justice, at that time we called it Aboriginal justice, that we will be judged at the end of the day by what we do on behalf of Indigenous peoples. I remember him saying, this is not a vote-getting issue, but this is to be a whole of government priority. And I was asked to chair a cabinet committee with regard to Indigenous peoples. And while I was Minister of Justice and working together with Paul, this was one of our priorities and remains for me a priority in our work and in the work of Raoul Wallenberg Centre. When we had the National Day for Aboriginal Peoples Remembrance and Action last June, we held a major workshop and webinar on that in the presence of Paul Martin, Phil Fontaine, Kathleen Mahoney, those have been involved in the discovery of the graves of children, unmarked graves, one of the more horrific actions that continues to be exposed and discovered, and where we have to have this serve not only as acts of remembrance, but of a reminder of our responsibilities.
I said we would address, at least in brief, the situation in Ottawa at the moment, and I don't want to renege on that promise. I think there's some people around who remember the imposition of the War Measures Act, which was 1970, and that involved soldiers on the street in Ottawa. And I think the detention, the arrest, and the holding without charge of nearly 500 people resulted from the murder of the Quebec Cabinet Minister Pierre Laporte and the kidnapping of James Cross, the British diplomat. But what is the difference with the Emergency Measures Act imposition and the situation back there? Is this better?
Well, there's a difference in both pieces of legislation. I recall the first one very well because I was then, Paul mentioned it, I had gone to teach law at Osgoode Hall Law School. It was my first teaching responsibility in the fall of 1970. That's when the War Measures Act was invoked. But at the same time, I had worked, in my first professional public service involvement was as a special advisor to John Turner when he was Minister of Justice from 1968 to 1970. I then started teaching at Osgoode. It was remaining part-time for John Turner, and therefore was coming to Ottawa 2 days a week at the time, and was involved with respect to the imposition of the War Measures Act. I know that John Turner, and he wrote about it, he was reluctant at that time with regard to the imposition of the War Measures Act. But what is sometimes forgotten is that there was a unanimous request by the provincial government at that time for the federal government to impose the War Measures Act, and a request from the city of Montreal and the mayor at the time. So within the principles of federalism as well, it was felt that federal government had to respond to the unanimous call from Quebec, from the city of Montreal, with regard to the imposition of the War Measures Act. Now, there were cases of arbitrary detention that had emerged, etc. But I think the background to that was the fact that there were these calls, and as you mentioned, the murder of Laporte and the like. Now, in this instance, we're dealing with a different piece of legislation. We're dealing with the Emergencies Act, which was adopted in 1988. This is the first application of that legislation. Frankly, I initially was somewhat surprised because I felt that there was sufficient authority in the law and in law enforcement so as not to have had to invoke the Emergencies Act. But it appears that events, started to spiral beyond the city of Ottawa, involved bilateral relations with the United States, etc. And so the question with regard to the invocation of the Emergencies Act is, number one, and this is what makes it different from the War Measures Act, is that it is limited in time. It requires a parliamentary oversight. and it also has to comport with the principles of proportionality. So we still will have to see that the oversight, parliamentary oversight, is carried out, and that a determination is made that it was measures taken were proportionate. And an important difference here, as well as that the Charter of Rights and Freedoms, which you so importantly highlighted, still is in effect. It's in no way affected by the invocation of the Emergencies Act, and therefore authorities are held to account and rights remain and are to be protected under the Charter of Rights and Freedoms, and it is for a limited time frame only. And as I say, the oversight by Parliament will be forthcoming.
So it's 30 days, I believe, no more than that.
Yes.
Presumably
Right.
can be extended. What about the rights to demonstrate, the right of freedom of expression, the right of freedom of speech? How do you balance those rights? Because those in the convoy have rights.
Yes, I put out a statement at the beginning in which I said that freedom of expression, association, and assembly are cornerstones of our democracy and must be protected. I said, however, the invocation of Nazi symbolism or racist symbols, whether it be the swastika or the Confederate flag, I said, are an assault on memory and on truth. And while we must protect not only those rights that I said that are a cornerstone of democracy, and the right to protest, and the right to protest against vaccine mandates, if that is what is felt to be the subject matter of protest, one cannot at the same time allow oneself to be associated with the invocation of racist imagery and symbolism. That's not part of the protected framework.
Thank you. Thank you very much. We're reaching the end of our prescribed time here, and I know I didn't mention that you tonight are in Jerusalem. It's extremely late for you, so I thank you for giving us your time, and I'm going to hand it back over to Paul to wrap up this evening. Thank you very much, Irwin.
And thank you, Cam, for your really expert moderating of this. And you were evocative in your questions and therefore helped to facilitate a better response.
Thank you. Paul, over to you.
Thank you very much, Karen. As it has just been expressed, for moderating this evening. You've done a great job. And special thanks to you, Irwin, for providing us with some insight into the world of the politics of human rights. I know that you've been described as a string-thin lawyer, but that was only descriptive of your physical stature, not the capacity of your heart and incisive mind. Wishing you the very best as you fight on. Until next time, thanks, Irwin. And thank you to our Zoom audience for joining us this evening. For without you, we would not be inspired to seek out the best topics and speakers to enlighten your life's journey. Our next topic will be Alberta Rebranded, with 11 opportunities for you to spend time with us exploring the history and the today and tomorrow of Alberta. Learn about populism from the mouth of Preston Manning live at Victoria Hall, and relax and laugh with B.J. Smith describing the cowboy and his life in poetry at the Capitol Theatre. Check out our website for all the opportunities to learn about the evolving Alberta, with the first event beginning on March 24th. Now, before you sign off, we ask you to take 30 seconds to answer a few survey questions that will pop up on your screen. Thanks for joining us this evening, and we look forward to seeing you in Alberta. Good night.
Thank you, Paul. And I look forward to being able to attend your excellent forums as you've represented them. And one of the best things that has happened as a result of our encounter this evening is you have me now as an attendee, that I can be a beneficiary of your great events.
Thank you so much, Irwin. And do have a good day tomorrow.
Stay safe and healthy, everyone.